All right, let's stay with this particular developing story now and speak to legal analyst Mpumelelo Zikalala. Thank you so much for your time this evening, Cousin. Let me start with the IEC's lawyers, of course, arguing that the Electoral Court was fundamentally erred, in fact, according to them, when it found that the remission of sentence reduced former President Jacob Zuma's sentence from 15 to 3 months. And then listening to what is coming out this afternoon as an argument from his lawyers, they say that for them a remission has the effect of a discount when it comes to a sentence. So what is your view then on this particular argument?
Good evening, Manget, and also to our viewers. I think it's important to look at how the text is written if you look at the certain powers. Firstly, let's look at the powers which are available to these two entities. I say entities because you have entity one, which is the courts, that says we are going to issue our sentences throughout. That's our job to do on a regular basis. Then secondly, if the powers which are then attached to the president as per the section 87, if I'm not mistaken, of the Constitution, and then you have section 2 of the Constitution that says the Constitution is the supreme law. There's no other law above that, meaning there's no other precedent or formation or any other framework that you can go to. If the Constitution allows it, then so be it. So the contention which I would to sway towards would be to say the president does have powers to exercise his powers in terms of the Constitution, and if those powers equal a remission, then so be it. Now go back to the remission and what it exactly says. Look at what is written within the particular context. It talks about pardon, it talks about remission, it talks about all the other things that are there, all in one sentence, giving the impression that the drafters of the legislation or of the Constitution knew that these are going to have different impacts and different results depending on how it is applied. Now, on a basic definition of what it means to remit, it means to take away. Now, if a certain portion of a person's sentence it is then taken away, then it can't be said that the person has served these particular sentences. It does not say anything about whether the person is going to apply for the duration or the serving of that particular sentence. So to me, once the president has issued their powers as per the Constitution, whatever sentence which was issued by the court, then, or whatever amount is then taken away by the remission of the president. So if it does not fit in within the 12 months which has been identified, then the former president should be allowed to go and his name should appear in the list that is going to go to the National Assembly.
So then one is asking, in light of what you're saying then, in simple terms, if you remit, as you say, you remit, you take away. So does it mean then that it puts the sentence at 3 months instead of the original 15 months?
Correctly. And the instance of the results of that is that it is then within the time frame, the allocated amount that has been stated by section 49 of the Constitution. So if it's not more than 12 months, it means that the person qualifies, regardless of the fact that they've been convicted of a crime.
At the heart of this as well is the implementation of Section 47 as to who has the powers then to implement it. And in their opening arguments, you listen to the former president's lawyers who are saying that they don't believe that the IEC even has the powers, to do this. And they believe that for them, the IEC has no business implementing Section 47. And they believe that, in fact, it is the National Assembly, while the IEC is arguing otherwise and also asking the court to make a ruling on this particular matter, in particular for future elections as well. How important will this be for the court in order to ensure that this is in fact clarified?
It's very important, especially for the IEC, to know what are the powers that are vested within the IEC. If you look at the applicable legislation, it is the IEC that decides what's going to happen within that list of the National Assembly. Legislatively, all the legislation that we have dealing with all the elections that we have, they point towards one thing. The IEC is the one that is the sifter, is the one that regulates who goes into that list, hence why the provisions which then allows you and I to object to the names which are going to appear in the name of the National Assembly, they lie within the IEC, not within the National Assembly. So it is uncomprehensible that at the end of the day, you are going to have a list which is going to go to the National Assembly, in which 50% of the individuals that are there do not qualify. Then how does the National Assembly goes on with the business of the National Assembly and the business of Parliament? So what the law actually states now, it says, yes, the person who is going to be served is the National Assembly, but the person who's going to decide who the list should be, make sure that the proper vetting process is done correctly, is the IEC, because the mechanisms and the tools for that sifting and those objecting purposes, it is vested within the Electoral Act. And the Electoral Act then takes precedence. So the IEC would embark on that and say, we are going to go through that process and hand over to the National Assembly a list of individuals that are eligible to be there.
So, one then could ask the question also to say that, so let's say, for example, the court then says, yes, actually, this particular decision does rest with the National Assembly and not the IEC. One then would possibly then ask a question to say, if it rests with the National Assembly and then a person has been voted in by their voters, then get to the National Assembly and the National Assembly says, unfortunately, you're not eligible. A lot of question will arise as to what happens then to their votes that they would have gotten.
Precisely the fact, that's why this particular act and this task of choosing whose name is going to appear in the list of the National Assembly resides with the IEC. There's no legislation that is there. There's no instrument which enabling instrument that allows the National Assembly to do that. All the instruments are vested within the IEC, and it's the IEC which is going to say, these are the individuals which are going to go in there. These are individuals that are going to be voted upon. They are eligible to be part and parcel. Legislation is there and allows it. So even though at the end of the day you are going to serve at the National Assembly, but your door or the entry point or the starting line starts within the IEC, and it's the IEC that goes through the process of sifting and checking, are you eligible or not? And if you're not eligible, they're the ones that are going to tell you that you're not going to make it part of the National Assembly list. And
finally then, to something that happened earlier on in the court, I mean, the unsuccessful bid by the former president to have some of the, the justices recuse themselves because they believe that they may have an unconscious bias towards them. Your reaction to that earlier ruling?
I think it was a precedent ruling. It has essentially developed the law as we know it as to what is looked at when it comes to interpretation. It has added another dimension to it. Previously, the test would have been, in the mind of the subjective litigant, do you have a reasonable element of bias that bias is going to be applied to you? If the answer is yes, then recusal is then to follow. But what this ruling did today, it then said, go on a step further, look at the case, look at the merits of the matter, look at the facts of the matter, look at the point of law which is being argued. Is there close nexus to your element of bias, or is it just a personality trait in which you are saying to an individual, I do not trust that you are going to be independent in your assessment? If that's the case, then look at the second part of the assessment, which has now been developed after this ruling. So whenever an application for a recusal is being made, a person making that particular application would need to satisfy two things: subjective element. Secondly, look at the merits and discuss what point of view is being discussed here, how the lines are going to be blurred, and whether there's a close nexus between the independence of the presiding officer compared to the person who's the litigant, who's going to take part in that litigation.
Quite an interesting development, and let's see then how this particular one then unfolds, because as you say, it's critical for upcoming elections. But thank you so much for your time. That was legal analyst Mpumelelo Zikalala.